Should I be filing my trademark in my name, another founder's name, a CEO, or for the entity? This question is actually very key and can result in a trademark registration being voided if it's answered incorrectly. Hi, I'm Jason Rosenblum. I'm an intellectual property attorney protecting my clients' products, their brands, and their businesses from getting ripped off. A question that comes up very often is, who is the applicant for the trademark? Who's the owner of the trademark? Ownership is actually very key. It's the owner that gets to file for the trademark. And here, as you can see, an application that is not filed by the owner is considered void. So even if that goes all the way through to registration and you point out that it was the wrong applicant, it can be voided. And essentially, all that time and money spent on obtaining the trademark would have been wasted. So who is the right person? Normally, in most cases, you have a business that is both designing, manufacturing, and then selling the product. So it's clear that that's who should be filing the trademark for that product. But sometimes maybe you have a new product. You're not selling it yet. And maybe you're deciding whether or not a different division or a different LLC or entity is going to be created for that. And you're not sure. And you might file under what's called Section 1B. And that is intent to use. I have a good faith basis. I'm going to use this in the future. Something that's very key here is that, as you can see here, this must be filed by the party who has a bona fide intention to use that trademark in commerce as of the filing date. And what happens is that means that you cannot assign that application until you actually have filed use for it. So you really need that entity, the person, whoever it is that files for that application, is the one that is then going to use that. And for an intent to use application, you can see, I'll put the link in below, essentially go through the same process as you would if it was a use-based application, meaning you're already using it in commerce, where the USPTO reviews it, you go through, hopefully you get to publication, and then after publication, you receive a notice of allowance saying, hey, now show us how you're actually using this in commerce, or you can pay for extensions of time. But when you show who's using it in commerce, should be that it was the entity that originally filed it. A lot of times, clients are like, oh, well, let's file it under this entity, and at a later date, we'll create a new LLC or a new entity that will be selling that product or take over that division. Unfortunately, under an intent to use application, that wouldn't work unless the original party that filed is the one to sell it, and then you create that new entity and transfer all the rights and everything thereafter. Another key issue that we see is a lot of times people file in an individual's name. Even though they have a company, S Corp LLC, they file for their individual name thinking like, well, I want to own this. I was the one that thought it up. Unfortunately, trademarks don't work that way. Trademarks are all about source identification. Where are these goods or services coming from? So if the goods or services are coming from an entity and that entity controls the nature and the quality of those goods or services, that's who should be filing for the trademark. So this is very key. As I said before, it can result in having a voided application or result in a voided registration, even if you get through. The examining attorneys generally take you on your word as being the owner, but if there's a dispute later on, it could be voided. So this is key, making sure that the proper party that has the control over the quality and nature of the products or services is who should be the owner. If you have any questions about this, feel free to reach out to us. If you like these, please subscribe below. You can always reach us at 888-666-0062 or for more information in the links below. Thanks and have a great day.